Today we're going to be speaking with Stephen Gilchrist, a partner in the regulatory department of Saunders Solicitors LLP. We're going to be talking about the new law governing corporate manslaughter, an important new development in the field of health and safety. Good afternoon, Stephen. First of all, what is this mysterious concept of corporate manslaughter?
Well, corporate manslaughter deals with a situation in which a company may be prosecuted for manslaughter or unlawful killing, which takes place in the course of its operations.
Right, this is a bit of a hot potato at the moment. Why is there such concern amongst the public?
The problem has been that companies hitherto can only act through a human agency, that's to say its directors or its managers or its employees. And so you have to find a controlling mind that is responsible or has been responsible for the fatal accident, and it's sometimes difficult to do that.
Now, can you explain this in real terms, perhaps using an example?
Yes, take for example the P&O Ferries case in 1991, which arose from the sinking of the Herald of Free Enterprise ferry in 1987. Now in that case, directors and employees of the company were prosecuted for manslaughter, and they were all acquitted. There were no convictions. And although the court in that case said that theoretically a company could be prosecuted for corporate manslaughter, in that particular case the court could not find that there was a controlling mind within the company that was actually responsible for the default that caused the fatal catastrophe.
So that was back in the early 90s. Why is it only now that we're seeing a change in the law?
There's been discussion about this for a number of years, but the situation and the debate was really reignited by the failure of criminal proceedings in the Hatfield case. No convictions there, and so there was concern expressed by trade unions, victim support groups, and pressure was put on the government to introduce new legislation, which it now has done.
What's the new legislation called?
It's called the Corporate Manslaughter and Corporate Homicide Act, and it comes into effect on the 6th of April 2008.
How is this new act going to change things?
Well, the Act is geared to target companies and to prosecute companies where there's shown to be a gross failing in its health and safety activities and responsibilities leading to a fatal accident.
So the law is going to apply to limited companies, PLCs?
It's going to apply certainly to limited companies and PLCs, but not only that, it's a very wide-ranging Act, and it governs all sorts of other entities that could be regarded as corporate entities, government bodies, government departments, prison service as an example, the Scouts, employers' organisations, trade unions, limited liability partnerships, and partnerships of other kinds.
Now, as you said earlier, under the existing common law manslaughter, companies could already be prosecuted as well as individuals. How does the new Act alter that picture?
Well, the new Act, as I've indicated, is geared towards prosecuting companies. Individuals cannot be prosecuted under this Act, nor could individuals be convicted under the new Act of, for example, encouraging or assisting a company to commit manslaughter. However, that's not to say that the existing law doesn't still continue to apply in relation to individuals. If an individual is regarded as being responsible for gross negligence leading to a fatal accident, then that individual can be prosecuted under the current law and of course under health and safety legislation as well.
So who's going to be responsible for investigating, deciding whether there should be a prosecution and then prosecuting under the new offence?
Well, the investigating authority, the lead investigating authority essentially is the police, and the police will harness the expertise of other regulatory bodies such as the Food Agency, the Rail Regulator, the Health and Safety Executive in undertaking its investigation, but it will be the police that will lead the investigation. So far as prosecutions are concerned, that will be in the hands of the Crown Prosecution Service in England and Wales, but again they will liaise quite closely in accordance with current protocols with other regulatory agencies.
If a company finds itself in the situation of being prosecuted, What is it exactly that a court or perhaps a jury will be looking at?
Well, you have to remember that the Act, whilst it deals with the management of a company's activities, isn't restricted in looking at any particular layer of management, although a substantial part of any gross failure must be laid at the door of senior management. So one's looking essentially at any systemic weaknesses within the company, whereby the company is likely to breach health and safety law or indeed fail to comply with its own health and safety policies.
Now obviously corporate manslaughter prosecution is going to be reserved for the most serious of accidents, but what sort of threshold are we talking about before a decision is made to launch a prosecution?
Well, essentially the threshold is one of gross negligence. That's to say gross negligence in a failure by the company to comply with health and safety law, to comply possibly with its own health and safety policies, but it's also looking at the ethos and the attitude of the company towards health and safety generally. And juries, as I've said, will be looking at possible breaches of health and safety law.
Now, you're obviously a specialist in this area. What sort of advice would you give to senior management who are trying to prevent a catastrophic event like this from happening in the first place?
Well, you have to look at your health and safety policy. You have to ensure that the policy is sound, that it's consistent, and that it is complied with by all levels of employee. That means a review, an audit, if you like, of health and safety policy at regular intervals, and an assurance by senior management that that policy is being complied with.
Now, you say senior management. What exactly does that mean?
Well, senior management doesn't necessarily just mean a manager or a director or an office holder, if you like, of a company. It rather depends on the size of the business. For example, in national companies, senior management could mean regional managers. In large companies, it could mean the operators of departments within the company's operations. So it rather depends on the size of the company. Clearly, senior management will always include directors and office holders, but it's not necessarily restricted to those people.
Now, say the worst comes to worst, there's been a terrible accident and a company, for instance, is being prosecuted for corporate manslaughter. If the company is convicted, what sort of penalty can it expect to receive?
Well, obviously a company can't go to prison, so the principal penalty, as it is at the moment, will be a financial penalty, which may be substantial. But there are new provisions in the Act which allow the court to make other orders, and in particular a publicity order. Now, a publicity order is an order which the court can make compelling the company to advertise the fact of its prosecution and its conviction in any way that the court orders. Could be in the media, could be on its website, could be in its own written material. That is not going to be very helpful for the company in a commercial sense, because it may affect, for example, its share price if it's a PLC, or issues such as competitive tendering. Likewise, the Act also provides for a remedial order. The court can order the company to remedy any of its failings which may have caused the accident, and remedy them forthwith. And that is something new because it's not currently available under corporate manslaughter law as it stands at the moment.
Do you have any sort of idea how large these fines could be?
Well, it's very difficult to say. There is a Sentencing Guidelines Council which is going to look at this and set tariffs. I think the government expects the financial penalties to be much in line with current health and safety financial penalties. For example, some of the larger penalties in recent days have included fines on Network Rail and Balfour Beatty of many millions of pounds arising from the Hatfield disaster where health and safety breaches occurred. Likewise, Transco were fined, I think, some £15 million as a result of fatalities arising out of the Lark Hall incident. So they could be substantial.
Finally then, last piece of advice. What would you say to companies who are worried about their vulnerability to this sort of event from happening?
Well, prevention is always better than cure. The advice I would give to senior management in companies is to ensure that they have a clear, consistent and current health and safety policy, to audit their policy and their health and safety activities regularly. If they find that they are at the sharp end of a prosecution, to seek immediate expert legal advice to help them at all stages through the investigation and the prosecution.
Stephen Gilchrist, thank you very much.